See if I can find a nifty comment here to read to you. Infamous crimes are thus in the most explicit words defined to be those punishable by imprisonment in the penitentiary. The result is that all the crimes charged against the defendants in this information are infamous crimes. An infamous crime is synonymous with a felony within the meaning of the Fifth Amendment of the Constitution, and that the defendants cannot be held to answer in the courts of the United States for any of those crimes otherwise than on a presentment or indictment of a grand jury. Read these two cases, and I'm telling you, you're going to receive some information and some education there that'll just, as the street language goes, blow you away. In Idaho, we don't have any public prosecutors. So what isn't said in Section 8 here, Article 1, Section 8, is more eloquent than what is. We've got these prosecuting attorneys and city attorneys prosecuting cases in the name, get this, in the name of the state of Idaho. Prosecutions in this state, says one of our more eminent judges, whom I was just before the other day, says, all criminal matters in the state of Idaho are brought in the name of the state. Well, Your Honor, are they the party of interest? Yes, they're the party of interest. Oh, well, gosh, that's interesting, because you see, if the state is the party of interest, you know you're in an equity jurisdiction, you know you have to be taken to a grand jury, and that you cannot be prosecuted by information because of Article 3, Section 2. And listen to this, in all cases affecting ambassadors and other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. And that's why I'm telling you right at the beginning of this program that the court of original jurisdiction, and the one court in the United States that is our common law court, is that Supreme Court in Washington, D.C. Because of the Miranda Doctrine, where rights are involved, there can be no rulemaking or legislation that would abrogate them. Okay? All right, so if you drew out a little schematic like I've done right here, right up here at the very top, I simply wrote down the common law and equity. And I drew a line. And under equity, for instance, I drew a line and I said, it's civil or criminal. Well, under criminal, under civil, there are no criminal penalties. So that's one of them by itself. But under the criminal line, criminal cases are divided into two branches: misdemeanors and felonies. When you're talking about infractions, you're talking about civil law, not common law or equity. That's civil law, and that's pure contract. That's where you go out and you get a driver's license, registration, and proof of insurance, and now it's simply a matter of enforcing the insurance company's contract. And in order to do that, they have penal clauses, and that's why your statutes are called penal statutes. Remember, we've talked about this before. Penal statutes then punish you for breach of contract. But when you're under common law, you've got to be prosecuted by the people of the state, by a public prosecutor for a public offense. Selling beer to minors isn't a public offense. Selling beer to minors, if you're a clerk in a store, isn't a crime. It isn't a misdemeanor. It's a civil action. It's a civil action because the clerk of the store is acting under the employment contract with the licensee, which is the store. That's how simple that is. The store has the license. The store comes under the penal clause. You know, most of the statutes in Idaho are civil. The statutes of Idaho are really civil remedies. And in the state of Idaho, there are only two causes of action. And our Constitution lays those out. Let me see if I can find them quickly. They're criminal and civil. Or if I can put my finger on it. Well, I can't right off the top of my head, and I don't want to waste time here on TV tape doing it, but we have civil and criminal actions. That's all there is here. And when we pass statutes in this state, when a free man is involved, his Constitution comes into play first. And it's got to be a public offense. And we haven't had grand juries in this state, and it's been rumored for 18 years. I don't know when our last grand jury met in the state of Idaho. But now let me tell you what we just did recently. We went into court on a felony issue, and we brought up 8 jurisdictional defects in the information. And we laid them out in front of the court and said, as an example, the people of the state of Idaho are not represented in this court, Your Honor, and therefore this information fails. The party of interest in this case is the state of Idaho, which is a paper fiction, and therefore the action before the bar is a civil case. It's a civil issue. Number 2, we have an information, Your Honor, and pursuant to the Wilson and the Mackin cases, I demand a grand jury as a matter of right. Number 3, Your Honor, our state constitution guarantees me the right to a grand jury indictment in all cases of any grade in the state of Idaho by grand jury, except on information of the public prosecutor, and sir, the gentleman sitting over here to my right is not a public prosecutor. He's a prosecuting attorney, and he's identified as a prosecuting attorney by Article 5 of our state constitution. Now, when I went through the 8 jurisdictional defects, it took 3 hours, or about 3 hours, to deliver that sermon to that court. And let me tell you, we laid it on, and we laid out our constitutional rights in spades so that there'd be no misunderstanding. When I was finished, the prosecutor brought up 4 statutes, which we had already brought up and demolished, and said, well, I just brought this information because the statute tells me to do it. Which leads us to the conclusion that Judge Berger was correct when he said that 90% of the lawyers in the United States are incompetent. I think he knows what he's talking about, because Judge Berger probably studied law at a time 40 or 50 years ago when a lawyer had to know some law in order to pass the bar. I don't think lawyers coming out of law school today could pass a bar examination of 1930 or 1900. They're wrapped up in corporate law and statutory law and rules and regulations of the old Roman civil law, which is in reality simply private mercantile equity that's being worked upon us because we cannot demand our rights because we don't know how. While I was in court waiting to put on this motion hearing, I saw 5 arraignments, and all 5 of those people pled guilty or not guilty to an information and never demanded a grand jury. Well, if you don't demand your rights timely, if you're not that belligerent claimant in person, remember this book here called Legal Quotations. I've got to stop here for a moment and read this as I cover this on page 32. The privilege against self-incrimination or rights of any kind is neither accorded to the passive resistant nor to the person who's ignorant of his rights. And so here you got 5 other people in the court with me. They always save me to last so the slaves don't see what's happening to them. And these people are pleading not guilty to an information. What's wrong with that? They're in effect saying, yeah, I'm in mercantile equity. Yes, I come under the sovereign statutes, the sovereign legislature of Idaho, and yes, I plead not guilty to this act, and I should be tried in this court. And no, you don't need any grand jury. Nor the person who's ignorant of his rights, not to the one who's indifferent. And here's these people, they're all indifferent to the Republican form of government. It is a fighting clause, and its benefits can be retained only by sustained combat. I'm on page 32, by the way, of this Legal Quotations book, in case I forgot to identify this one. You ought to memorize this and have it on the tip of your tongue. You know, I always tell students not to memorize things, but there are some real classics. It cannot be claimed by an attorney or solicitor. How do you like that? Doesn't everyone go to a lawyer when they have a legal problem? Here's your Supreme Court in Washington, D.C. telling you your rights cannot be claimed by a lawyer or a solicitor. What is a solicitor? You ever seen a solicitor on the street soliciting? Attorney or solicitor. It is valid only when insisted upon by a belligerent claimant in person. If you want your Constitution and common law rights, you're going to have to claim them. All right. So let's run over this 222 rule so you have it firmly embedded in your mind so that when you go into a court, which you can almost bet is always going to be equity, but you ought to at least understand the definition of the 2 courts. You've got equity and common law. Equity attempts to enforce statutory provisions and enrich the crown, and the common law addresses the issue of public offenses and crime in the name of the people. And you have common law rights embodied here in your Constitution. All right? Now, under each of those two major divisions of law, equity and common law, and you can also say under equity you've got admiralty jurisdiction, because we are all in not just form, but in substance in an admiralty court, an admiralty jurisdiction. We're treated just like you would be if you went to an admiralty court pursuant to a high seas issue. They're divided into criminal and civil. Civil is not divided in anything else, but criminal is divided into felonies and misdemeanors, and a felony is an infamous crime. And I'll have some information in later segments of the course, and I'll show you how that a misdemeanor has to be addressed by a grand jury also. But let me suffice it to say at this point in time with this lesson, the Supreme Court has not said that you cannot be prosecuted for a misdemeanor by information or complaint, because you can't. You see, you can be prosecuted by information or complaint if it's something less than an infamous crime, because the Fifth Amendment does not address misdemeanors. But I'll show you how to address misdemeanors and how to force them into a grand jury indictment for a parking ticket. You have a right to a grand jury indictment for a parking ticket if you're a free man. But if you have a driver's license, you can forget it. You're an administrative practice, you are in administrative law, and for that reason you're not entitled to any rights, other than those civil rights that are granted by your sovereign, the legislature. All right. Now the next thing I want to bring up is this thing of what says here, it's a misprint, it says axioms of equity. Actually, it should read maxims of equity. And right here, I'm looking at Bouvier's Law Dictionary of 1914, I believe it is, and under the rules of equity. Now let me read to you some of these rules of equity and give you a little idea here as to what equity is all about. The most important maxims in equity are as follows. 1. He who seeks equity must do equity. Okay? 2 contractual parties. You've got the insurance company and the insured. Each one of you must live up to the terms of the contract. He who comes in equity must come with clean hands. Okay? Very simply. You can't come into the equity court, you can't come into, say, a small claims court with dirty hands. You've got to be the guy with the white hat. You've got to be clean. Equity aids the vigilant, not the slothful. Okay, so you better be vigilant. Equity acts specifically. Equity acts in personam, that is, it has a performance from you. Equity follows the law. Equity suffers no wrong to be without a remedy. Okay, so the equity judge is going to cut the baby in two. Equity regards that as done which ought to be done. Equity regards the substance and intent, not the form. All right? Now that's important to note, a distinction in equity versus common law. You know what, the old common law, if the bill wasn't filled out, it wasn't a true bill of indictment. There's a case in Idaho called Hopkins versus Idaho in Book 40. I forgot the page number, but if you wanted to check it out, it would be 40 Idaho something, and the name of the case is Hopkins, Hoptkins, I believe it was. This guy was in jail for 17 years. He had been indicted by a grand jury, probably around from what 40 sounds like in the 1920s or so. But the true bill was, the form of it was in error, so on a writ of habeas corpus they turned him loose. In equity they wouldn't do that. They would go by the substance. But at the common law, the form had to be correct as well as the substance. Equity regards the substance and intent, not the form then. That was number 9. 10. Equity implies an intent to fulfill an obligation. To fulfill an obligation. Intent to fulfill an obligation is a contract. Equality is equity. Where the equities are equal, the law will prevail. So if you've got two people here who have similar claims, both pursuant to the statute, then they will go to law, and the law will prevail. Well, I'm a citizen at the common law, and I always want law to prevail. Where the equities are equal, the first in time will prevail. While these phrases and expressions may sound vague, they often have concrete application. All right? Now, I'm not going to go through here and plead equity because I'm not here to teach equity. I'm here to teach you that that's what they're doing to you. They're applying contractual agreements to you. We've, in our dialogue here at the school, talked about what is a free man and how do you get free. Now, I'm not totally free either. You know, I still have a marriage license and I still send my kids to the public school because I'm well aware that we have three parties to a contract. We have a license, and George Gordon and his wife and the state of California, in my case, are the parties to a contract. If I want to get divorced, there's no common law action. There's not going to be any jury to decide what the property settlement should be or where the children should go. That's the state's prerogative by statute because we voluntarily acquiesced to the equity jurisdiction of administrative process through the state courts. So if I want to divorce my wife, we're going to be divorced, and we're going to be divorced in a state court, and that court is going to decide how the divorce settlement's going to come out. And they're simply going to rule based upon equity. And they're going to use these maxims of equity. And let me tell you, they're cast in cement. If I were going to get married again, I would get married at the common law by contract, because after all, that's a religious issue under the First Amendment of our federal Constitution. I don't need my government's permission to get married any more than I need my government's permission to go to baptism, or to go to communion, or to go to any other religious function. I don't need it, and I won't ask them for it again. Unfortunately for me, we have not worked out the solution to the marriage license. We do have the solution to the driver's license, and we have solution to business license, and the solution to property, and zoning, and planning. I can show you how to go in. When you get through with this course, you can go into any court and stake out your 9 square feet and argue your position. But when you've got the license, when you've got the contract, when you're participating in a government franchise, you're not exercising rights. You're exercising contractual privilege. Take a look at Hale versus Hinkle here, shall we? Let's take a look at number 20. Let's see, excuse me, it's on page 20, Hale versus Hinkle. Here's why a common law man, a common law citizen, doesn't owe any duty to the state, doesn't owe any specific performance, isn't subject to statutes and statutory jurisdiction. Reading about 1, 2, 3, 4, 5. Let's start on the 5th line down. We're on page 20. It's number 48 in legal quotations. He, that is the individual, is entitled to carry on his private business in his own way. His power to contract is unlimited. Think about the negative side or the opposite side of the coin. The individual's power to contract is unlimited, but the corporate or the enfranchised person's power to contract is limited. The individual may stand upon his constitutional rights as a citizen, but the enfranchised individual or the corporation is not entitled to stand upon the Fifth Amendment. He is entitled to carry on his private business in his own way. The individual is, the corporation and the enfranchised individual is not. Are you beginning to see now with your mortgage on your house why it is that you have to get a building permit when you want to work in your bathroom? Because you're working on the bank's house, the bank's bathroom. And since you're working on their property and you only have an equitable interest in it, you have to be regulated, made sure that the work you do to their property is done correctly. Nothing wrong with that. That's not an invasion of your rights. The invasion of your rights is when they sent you to those government schools and then they indoctrinated you with this notion that you're a free person, that you're a citizen. You're neither free nor are you a citizen. You're a member or a subject. You're not free. You're a feudal serf in mercantile equity. You're no better off than you would have been in 1240 in France or Italy working on a feudal farm or a feudal land or a feudal estate of some type. You have your equitable interest in your house, and you have an equitable interest in some land, an equitable interest in your tractor, an equitable interest in your farmland, but you don't own it. And it's a misnomer for government and bankers and others to be telling you, and teachers and educators and college professors, to be going around here calling themselves homeowners and auto owners and people like that. People rent their cars, they rent their snowmobiles, they rent their motorcycles. Just take a look at your own status in life and you can determine how free you are. Going on, he owes no duty to the state or to his neighbors to divulge his business or to open his doors to an investigation so far as it may tend to incriminate him. He owes no such duty to the state since he receives nothing therefrom. And there's the key to that issue. I don't receive anything from my state, so therefore I don't owe any specific performance to obey any statutes of the state of Idaho. And when the state of Idaho passes a statute and says, thou shalt do no murder, big deal. We've already got that law on the books. That law has been in existence for thousands of years. All that does is create a duty or obligation or a moral climate. Here's your state and its state religion. All of its churches out here who are organized under the corporate dictates of the state, and all the preachers and the ministers who are licensed under the corporate dictates of the state. So you have a merger of state and religion. And you thought that religion in America was separate from government. Nothing could be further from the church, from the truth. We have the same kind of Baal worship in the United States of America that goes under the guise of religion. You can name whatever religion you want at this juncture of time, but they had it in Nebuchadnezzar's time. Only at that time, they didn't make any bones about it. They just came out and said, hey, dummy, Nebuchadnezzar is God, there's the idol, bow down, or we'll throw you in the fiery furnace. In the United States, we're more circumspect than that. What we do is we run around and say, hey, you're free here. You're free to choose. You can choose any one of these 400 brands of poison that you want. And we're not going to interfere with your freedom of religion. Just as long as the guy is licensed, and just as long as the church is registered with the IRS, and just as long as the church is incorporated under the sovereignty and the authority of the legislature of the state, why, yeah, you can do whatever you want. So the church gets certain benefits, don't they? Oh, they get property tax relief, and they get all kinds of goodies, and they don't pay Social Security taxes on the preachers, and they get their parish houses without property taxes, and et cetera, et cetera. I could go on and on. I don't need to preach a sermon about that kind of baloney because even you're smart enough to figure that out. Okay? Just suffice it to say, you've got a merger of church and state in the United States of America. It's the way it is. It's a fact of life. All right. So when we're talking about jurisdiction then, we've got this common law. Here's our common law, which has been buried. You can't find it any longer under the statutes. And so you show me a preacher or a religious organization that wants to go out here and start telling people the truth about income and compensation. You know, there's only one group or body of people in the United States of America today, to my knowledge, who have got the intestinal fortitude to stand up in front of the public and say, listen, let me tell you how it is. Income comes from the source, not on the source. And income is not a tax on labor or commissions or tips. For all you waitresses out there that are paying income tax on your tips. And the body I'm referring to is our Supreme Court in Washington, D.C. They're the people that tell us that. They tell us that in Eisner versus Macomber and in Brushaber and Pollock. And they say, we're not interested in the definitions by accountants and bureaucrats and lexicographers. We've decided what the definition of income is, and income is a gain made from profit, or a gain or a profit made on capital, not labor. Working people shouldn't be paying income tax. You show me a preacher or a church that'll come out and teach you that. Let me know about it, would you? Because I haven't seen any of those. Now, I'm not going to go on on this subject of equity and go through more maxims here, but there's a definition for each one of these maxims of equity. I'm going to read one to you and kind of titillate you a little bit and get you interested so that you'll go look these up and read them for yourself, because the more gray matter, more knowledge you get in your gray matter between your ears, it makes a big difference when you're standing on that courtroom floor preaching a sermon to that judge. Because you're going to have to stand there and tell that judge, just like Shadrach, Meshach, and Abednego stood in front of that fiery furnace and said, well, I don't like what I see over there, and I'm not really too anxious to go to jail, Judge, but let me tell you how it is. I ain't going to bow down and worship your idol. Got that, dummy? Now, you better be prepared to go over there into the jail, because some of you are going to have to go into jail once in a while, but look at what clean hands say. When we observe, he who comes into equity must come in with clean hands, we mean that he who seeks relief in equity must not have been guilty of any evil conduct with reference to the transaction in question. All right? So when you come in, here's the doctrine of clean hands. You want your opponent to have dirty hands. Okay? He who seeks must do. That was number one. When we say he who seeks equity must do equity, we are basically parroting the layman when he says that one may not have his cake and eat it too. Okay? It goes on, and you can pick this out and study it for yourself. I just want to show you where to go get the information. I don't want to sit here and read to you. I don't think anybody needs reading lessons. There are your maxims of equity. Equity isn't all bad, and I'm not saying that it is. You know, oftentimes you'll have to get equitable relief. To give you an example of what we're doing there, I have sued out in this state for a declaratory judgment pursuant to the driver's license, registration, and proof of insurance. I've taken my cause of action. I'm acting on the roads openly, notoriously, and I'm claiming my right to drive on my roads, and I will not be compelled into a contract with my government. I will not get a driver's license. I will not register my car. I will not register my children. I will not register my television sets with my government. It's none of their damn business what I've got and where I've got it, and I'm not going to tell them. And if I need to, I'll go to jail for a few days to illustrate the facts. All right, now that much out of the way then. When we go into court, like I have on a declaratory judgment, we are seeking rights. And I'm demanding that the court rule on the rights issue. They take me out in the traffic court every now and again. They want to prosecute me and say, they get the jury over here, you know, and this man doesn't have a driver's license, and we have to have a driver's license, so he has to have a driver's license. Because I'm a slave, he has to be a slave. And that's the kind of mentality that you're up against in the opening rounds. But pretty soon, I just got word from our county jail. And I always like to get good words back, you know, because when you're in there in the early days, you know, there's a lot of degradation and humiliation. I heard the other day that some of the jailers out there have a great deal of respect for me. They think that maybe I might be doing something right. Maybe I'm not a complete lunatic after all. Well, gosh, that makes me feel good because I'm a peculiar person. I'm here all by myself. We were talking about a struck jury today and a jury of our peers. Can you imagine going into the courtroom and saying, I want a struck jury, Your Honor? I'll bet you there's not more than 2 or 3 judges in the state of Idaho that without looking in a dictionary could tell you what a struck jury is. I just bet you there aren't. I'll almost guarantee you there's not a lawyer in the state of Idaho that knows what a struck jury is. A jury of your peers. I don't think there's a jury of my peers in the state of Idaho. And there are some qualified peer jurors. There are some free men, but I only know of 30 or 40 of them. And I don't think that that would be a correct jury of my peers because they're all biased in my favor. I don't think you could get a conviction from a jury of my peers in the state of Idaho because I think I know almost all the free men in the state. I don't even claim to be free. I've still got that crummy marriage license. I wish one of you people out there would tell me I'd get rid of that thing. One of these days I'll get busy. My wife hasn't threatened me with divorce, and so I haven't felt any great and compelling need to get rid of the marriage license. All right, now let's take a look at the difference between a traffic and a magistrate's court. Magistrates are not judges. They're judges' trainees, and don't ever forget it. And you out there who are magistrates watching this film, don't forget your position in life. I think sometimes we tend to get elevated in our admiration and our opinions of ourselves. If you're a magistrate, you're a trainee to become a judge, and I'd like you to become a good trainee and learn what the law is so that you can administer it for those of us peons out here that want our rights. So the traffic court and the magistrates' courts, at least in the state of Idaho, those traffic court judges are simply administrative clerks. Any clerk could handle their job. There is nothing judicial about anything they do. Absolutely nothing. They use the form of judicial determination. They use rules of procedure that come from the courts. But they're pure equity courts. And what's worse, they're administrative equity. There are no rights issues involved. It's just a case of the policeman said you were speeding and therefore we know you're guilty. You've already had curbstone court by Officer Smedley. What you're doing here is coming in to tell me of any mitigating circumstances which might lower the fine, or you're appealing to me. Curbstone court to magistrate court. They're both about one and the same. As a matter of practical fact, you're not obligated to either one of them. Today I filed an appeal, or no I haven't. I've still got to file an appeal and I'm 2 days late. We're going to find out whether or not a traffic court judge is going to put me in jail for 35 days because I'm late on my appeal. My contention is she never had jurisdiction to start with, and Argersinger versus Hamlin comes into play. Yes, that's true. From time to time, we do like to test the system to see whether or not the judges will obey the law or break the law. There's one bright spot, though. If I go to jail for 35 days, I'll always take a couple of flare pens with me and a couple of writing tablets, and while I'm there, I won't be losing any time at all. In fact, I write more in jail than I ever do here at the office. That's one place where the telephone never bothers me and people don't bother me either, and I can just write to my heart's content. Roman mercantile equity. Boy, isn't that a mouthful. Roman mercantile equity is a branch of equity law which in reality is just simply private law. It's the law of private corporations. Mercantile equity and the Federal Reserve System go hand in hand. It's a private system of law. It's like working for a big corporation, and the corporation tells you to be to work at 8 o'clock, wear a hard hat, steel in your toes, and etc. And they have these rules, and these are called policies, and administrative policies. If you don't appear on time, and you don't have your hard hat, or you don't have your steel-toed shoes, what happens? They bring sanctions against you through the union, don't they? Don't they lay you off for a couple of days if you're tenured, and if you're not, don't they fire you or do something to you? That's exactly what they're doing to us here. No big difference. Here again, the jurisdiction fails, and when we talk about jurisdiction, we'll get into that pretty hot and heavy. All right? Chancery courts. What we thought we broke away from in England, from England with our revolution, was the Star Chamber Chancery proceeding. And these Star Chamber Chancery courts are exactly what our traffic courts are. I'll bet you if Thomas Paine or Tom Jefferson or Alexander Hamilton or George Washington, any of the early patriots, if they ever came back into court today, they'd say, why, that King George is at it again. Look at the way the form of this court works. Why, this is just summary proceeding without due process. They'd be exactly correct. You see, we've had this equity for thousands of years. We've had mercantile equity. Listen, it came from ancient Rome. We've had it for thousands of years. And it's a heck of a good system for businessmen, and it's a good system for stealing from people. It's a good system for business to sit in the counting houses, rubbing their hands gleefully, while we, the children of the patriots, toil in the fields producing their substance. But I'm tired of producing their substance, and I don't like it, and I'm going to stop doing it. And so that's why we're looking at a TV tape here today. All right. There's common law, equity, civil law, chancery courts, Roman mercantile equity, the traffic or the magistrate court. I went through these maxims of equity. Now I want to talk to you a little bit about this thing of the Constitution in the equity court, and I'm going to read to you some of these famous old quotations and some maxims of the common law, and I'll take that up right now. Okay, now I've picked up Bouvier's Law Dictionary, 1914 edition, under the subject matter of maxim. That's M-A-X-I-M. And while I was here, I just got to pass this on to you. I flipped over to member accidentally. A member is an individual who belongs to a firm, partnership, company, or corporation. So if you belong to a firm, membership, partnership, or corporation, that tells you that you're a member and not a citizen. And of course, if you've got a house and you've got a mortgage and the corporation owns the house, you can see that you're a member of the corporation. Now, to get back to the proper subject here, under maxims, let me just say a word here about what maxims are and how many there are. There's about 50 pages of maxims in Bouvier's 1914 edition. If you have a law library, you ought to look up that particular edition because it's got a plethora of information in there that you won't find in any other dictionary because it's later information than the 1870 dictionary, and of course Black's doesn't even know it exists, which is one of the big problems with Black's and some of the newer dictionaries. They don't have common law and old-timey law in it. So I'm going to start off, and I'm going to read to you some of these maxims. I can't read them all to you, of course, because we'd be here forever, but I'm going to take quite a bit of time, and I'm going to show you some of these maxims of law, and you'll have it permanently here on tape. And the purpose for using these maxims is that when you're writing motions, the court, that is the higher appellate courts, they recognize and understand the common law because they're there to decide rights and procedural issues. So anytime that you're using words like down the slippery slope or a maxim here, the foundations of the law and the conclusions of reason, and you go on through here to these various maxims, these are the kinds of terms and what we call one-liners that the courts use. Well, when those courts use those in their decisions and in their opinions, and you'll see it spread all over, all these Supreme Court cases that you read, you have 6 books of the key and fundamental Supreme Court cases. When you read those, they're liberally sprinkled with these one-liners. This Justice Douglas, you know, he was one of these so-called radical commie lovers type judges, you know. And he once made a statement that when people walk submissively, or those who walk submissively will say, there is no cause for alarm. But what of those of us who don't want to walk submissively? And we do claim that there is some need or cause for alarm. You know, some of these so-called radical libs came up with some one heck of a lot of nifty one-liners. And so when you're writing your motions, you need to be looking in here for lines that come out of Supreme Court and old common law cases. So let me go through here and pick out some of these that I've marked that are what I would call real classics, or at least extremely interested and extremely valuable pieces or bits of the old common law. I'm just going to flop open here. I'm on page 2148. No one is bound to accuse himself. Okay, does that remind you of the Fifth Amendment? See, no one is bound to accuse himself. No one can be compelled to testify against himself. Another one is, nothing is so contrary to consent as force and fear. Doesn't that speak to you about Miranda, that you have to make your decision knowingly and intelligently, not from fear or force? Nothing should be rashly changed. And the courts operate in a sphere of influence or a sphere of a methodology in their deliberations that run just like this. Nothing should be rashly changed, and they're very slow and they're very deliberate. And in all of the Supreme Court cases that I've looked at, I don't believe I can point to a case that absolutely contradicts another case. Even Knox versus Lee and Juilliard versus Greenman fit into an overall scheme, even though I don't agree with Knox and Lee and some cases on legal tender. I can see the rationale and the logic behind their decisions. 1, 2, 3, 4, 5. So that when change comes, it comes very slowly. It doesn't occur rashly. Nothing like comes out of our Congress. Our Congress can change law from one year to the next. It's like the 1977 bailout of Social Security that was going to last for 50 years or something like that. And here we are in 1983 with another major tax increase. I don't know if it's bigger than the one in 77, but it was a gigantic one. And they've said now that this will bail it out until the year 2020 or 2050, something on that order. You know about how long that's going to be bailed out, until about 1987. And then they'll have another massive tax increase. Nothing against reason is lawful. When you go into the courts of equity, you're not talking about reason. You're talking about expediency, or what seems to be fair and just. And that's what one of the major problems of equity is. It makes its decisions based upon the need or the expediency of this case at this moment in time. Next week you can have nearly an identical case and an exact different ruling or determination. But at law, the determination is always based upon the written law, reason, logic, and common sense. And that's why I'm so attracted to the old common law, just like I am to Scripture. And that is, it's always based on reason, logic, and common sense. No one is forbidden to set up several defenses. You notice that in our strategy of courtroom procedure, we bring in 30 issues. No one is forbidden to set up several defenses. You can set up as many as you want, and I don't see any reason why you shouldn't have 30. I have about 30 in my latest felony case. In case you think I'm a real bad guy, last year I was charged with tearing up a jail suit. They wanted to put me in the penitentiary for 14 years for tearing up a jail suit. And I never said I tore up that jail suit. Those guys out there jump to conclusions in the jails a lot of times, and they charge people what they call radical activists. So be prepared for that now when you go to working in the courtrooms actively in your local community, wherever you are. They'll look at you, first of all, as being a... no, they don't claim that you're a communist. I haven't been called a communist. They call me a radical. They call me an Aryan Nations. They call me a Nazi. They call me a constitutionalist. I mean, I'm called by every name that you can imagine except communist. I think communist has come to be a respected term in this country. No one is to be punished for the crime or wrong of another. That's the innocent party doctrine, or I am not the party of interest in this case. I don't want you to prosecute me. I'm not the party of interest. No man shall be condemned in his rights of property as well as in his rights of person without his day in court. Absolute right to due process of law. No man is bound for the advice he gives when you're acting as counsel. I'm not responsible for giving you faulty advice, and that's why I tell every one of my students, don't you believe a word I tell you. You go get Bovier's Law Dictionary 1914 and check out these maxims and make sure I'm not lying to you or that I'm not quoting it to you incorrectly. Don't take my word for anything. I never asked anybody to. That was Jimmy Carter that said, trust me. I'm not asking you to trust me. No one is above the law. Boy, a lot of people accuse me of that. They say, Gordon, you think you're above the law. You're better than everybody else. No, I'm just have a different status. I'm free and you're a slave. I'm sorry. Instead of trying to compel me to be a slave, why don't you try something new, unique, and different? It's called individual responsibility. Why don't you change your status from a subject to a free man? Take the license plates off your car and throw them away and turn your driver's license in and go out and work for a living for a change instead of living off the government. Do something real radical like that. He who stands on his own rights injures no one. Okay? When I'm standing on my own rights, I'm not injuring anyone. And a person who's not injuring someone has rights. Remember the Hale Doctrine? Good old Hale. Here's our Supreme Court again. He owes no duty to the state since he receives nothing therefrom beyond the protection of his life and property. His rights are such as existed before the law, or existed by the law of the land, long antecedent to the organization of the state, and can only be taken from him by due process of law. He owes no duty to the state since... Remember when you read the case of Miranda versus Arizona, where you picked out that case in 1637. The Supreme Court went clear back to 1637. I was in court a couple of days ago, and I cited which case was it? Mackin and Wilson, and this prosecutor jumped up like a little banty rooster on his rebuttal, and he said, why the defendant is relying on cases that are over 100 years old. Well, if you don't think I cut him and me, you know what. If the Supreme Court can go back 300 or 400 years to pull out a case, can't I go back 100? Is it the position of the prosecutor that the law changes every year and that we don't have any law because it changes daily? Well, certainly. His law changes every day. His legislature keeps passing new statutes, and the statutes change from year to year. You never know where you stand with statutory law. But I know where I stand. I don't owe any duty to the state so long as I'm not trespassing on the rights of my fellow citizens. He is a miserable slavery, or it is a miserable slavery where the law is vague or uncertain. And there you are, friends. The statutes are vague and uncertain. You couldn't tell me what new or what changes have been made in your traffic laws in the last 6 months. Boy, I sure don't know what's been done. I know of a couple of 3 major things, but how many of them have been changed or added? Now here is your common law telling you it is a miserable slavery where the law is vague or uncertain. And boy, let me tell you, it is slavery when you're bound to statutes. I used to operate a corporation, and let me tell you, boy, just trying to stand or just trying to keep up with any kind of standing at all with the laws and the statutes and rules and regulations, you're in violation every day. They can come in and lay you away anytime they want, and they don't need any intent. It is better to suffer every wrong or ill than to consent to it. You know, I tell people, if you're not prepared to go to jail for what you believe in and what you're practicing, well, you better get out of this. And here's your old-timey forefathers saying essentially the same thing. It's better to suffer every wrong or ill than to consent to this wickedness. The cause of the defendant is the better. Boy, I can say from experience, I'm glad somebody agrees with me because I'm the defendant most of the time. Although we're beginning to do more and more offensive actions. Listen to a few more of these. The law always intends what is agreeable to reason. Reason, logic, and common sense. You see where you'll find that? Maxims of law. The law always intends what is agreeable to reason. Let's see here. Law assists the wakeful, not the sleeping. Liberty is the natural power of doing whatever one pleases, except that which is restrained by law or force. So liberty is the natural power, natural, inalienable rights of doing whatever one pleases. I please to drive on the road without a driver's license, so long as I'm not bothering anyone else, except that which is restrained by law or force. Well, when the policeman comes out by force and yards you off to jail, I guess your liberty is being restrained, isn't it? All right, so our problem is, there used to be a time when we could drive without a driver's license. Where did that state ever get the idea that it had the power or capacity or the assent of the sovereigns out here to allow them to compel me into a contract? Since when do we grant permission for the government to compel us to sign a contract? That's the exact definition of tyranny. When someone can compel you to do something against your will and over your objection. The law requires nothing impossible. Boy, now that's a valuable one, because if you can't perform, if you can't pay the fine, that's why we have a law against debtor's prison. Let's see now, the fine's $200. How did you want to pay that, Mr. Gordon? Well, Your Honor, that's a good point. What kind of property is this court going to demand of me? Did you want hog fat or did you want walrus blubber? No, Mr. Gordon, we want lawful money of the United States. I'm glad you brought that subject up, Your Honor, because here I have the monetary powers and disabilities of the United States Constitution. And pursuant to this doctrine, pursuant to the Coinage Act of 1792 and all of the subsequent Coinage Acts, and especially the Monetary Act of 1972, there is no lawful money of the United States. You know, we have more and more judges that are coming to know and understand this money issue. And when they do, I had one the other day. I went out in court, and this particular judge, I don't want to say anything disparaging about her. She's a nice lady, and I mean that sincerely. She is a very nice lady. When it comes to law, though, she's just dumb as a post. And I brought up a statute, and in this state, and for those of you that are here in the state of Idaho, it's Idaho Code 2822-101. That statute declares what lawful money or money of account is of the state of Idaho, and it's called the dollar, cent, and mill. Okay? Well, what is a dollar? You have to have a definition. It's a measurement. And this book is it. This book, called The Monetary Powers and Disabilities of the United States Constitution, is available for sale. It is not part of this course. But if you want it, it's available, and it's called The Monetary Powers and Disabilities of the United States Constitution. It's a study in constitutional law prepared for the United States Gold Commission. It's about 309 pages long. Talk about maxims. This fella has got footnotes on footnotes on footnotes in here. I've never seen a legal brief ever put together with more precision and more compelling argument and more documentation. If you want to be able to go into the courtroom and argue money and what is a dollar and use this as an appendix to your legal brief, this is the one to use, because there just simply is no way to argue around it. And this fellow brought out an interesting statement. I realize this is a little digression here from the subject matter, but it's important, you know, when you see something that you make a comment on it. He pointed out that in the 1960s and 70s, mainly tax protesters and tax evaders have taken Article 1, Section 10 into the courts improperly. They have not taken it incorrectly. They have not made the major federal question. And the courts have almost universally rejected their arguments. They won't reject this argument. I don't believe it for a minute. We do have one case here in Idaho where we're going to use this monetary power and disability. Talk about maxims and axioms of law. This book is just filled with them. And you can quote out of this book, and you'll have the statutes, the federal statutes that are applicable, and you'll have the applicable case law, the intent of Congress, and the exact dialogue from the committees of Congress in many instances as to what the intent was of the law. This is an extremely valuable book. You go on to three more of these maxims, because I want to show you that by dictionary definition, that the law supports what our position is, and what your position is as a citizen who wants to exercise your rights as a free person. And the Supreme Court will back you up 100%. As who was this fella, Eagleton it was? Why, I back him 1,000%, said George McGovern of this one particular fellow that was running for vice president, or he'd named for vice president. And unfortunately, when it got right down to the nitty-gritty, they didn't want to back him very much. About a week later, they said, well, we're going to dump him from the ticket. And that's the kind of political backing of 1,000%. But I'm telling you, friend, that when you're looking at maxims of law and you're looking at your Supreme Court, I think that they will, and I think you'll agree that they do back you 1,000%. The law is the rule of right, and whatever is contrary to the rule of right is an injury. And a right cannot arise from a wrong. There's a little common sense from you. A right cannot arise from a wrong. A public right cannot be changed by agreement of private parties. Our constitutional rights, then, cannot be abrogated by some mercantile law or some company that has some mercantile interest, like the traffic courts or the insurance industry. That's a powerful statement when you stop and analyze the wording of it. A public right, that public right-of-way out there that you drive to work on every day, cannot be changed by agreement of private parties. That's exactly what they've done to you. The insurance companies have lobbied for statutes. The statutes compel you to get a driver's license and register your car and insure your car. Now here you are engaged in a regulated enterprise. You take your driver's license and try to argue your position in the courts, and you're in a summary process. It's like trying to argue with your boss at a big corporation that you don't need a hard hat. He just looks at you and says, "Boy, you'll wear the hard hat or we get somebody that will. We'll put you down here doing the worst job around the company plant. We'll have you out here sweeping cigarette butts off the parking lot." That's exactly what happens. Well, when you go to work for a company, you're there voluntarily. And when he tells you to come in and go out, you just shut up and come in and go out. You are, in fact, a servant. But when you leave the company plant and you start driving home, does that make you a servant? It doesn't make me a servant. And yet these corporations have imposed upon us corporate law, private civil law, and did it through our legislatures. In a doubtful matter, the negative is to be understood rather than the affirmative. Remember what I told you? When you're going to plead the code or plead the statute, what isn't said is oftentimes more eloquent than what is said. Now, in our state constitution, I want to read something to you here because I'm going to illustrate that point. It was under Article 12. In the state of Idaho, under Article 12, listen to these words, and let me show you how an opposite, a negative, comes up on the other side of the coin. In Section 2, it says, local police regulations authorized. Any county or incorporated city or town may make and enforce within its limits all such local police, sanitary, and other regulations as are not in conflict with its charter or with the general laws. Okay? Our city of Boise regularly brings cases in a criminal matter, in a criminal form, charging citizens with misdemeanors, and they're always entitled the State of Idaho Plaintiff. Okay? State of Idaho Plaintiff. Listen to this. Any county or incorporated city or town may make and enforce, within its limits, all such local police, sanitary, and other regulations as are not in conflict with its charter or with the general laws. Conflict with the general laws. Okay? What isn't said here is they don't have any capacity, power, or authority to prosecute the general laws. They don't have any power or authority to bring an action in the name of the state of Idaho. Our Constitution says that Boise City can sue and be sued. That's civil. The only capacity that a city attorney has is to sue and be sued. He's there to represent the municipal corporation. All Boise is, or any city in the state of Idaho is a corporation like Boise Cascade or Morrison-Knudsen or anybody else. Nothing more, nothing less. How would you like to be tried for a criminal prosecution by the corporate attorneys of Boise Cascade Corporation or of Merrill Lynch? What a crock of baloney. I can't even believe that these fools have even got the gall to do that. And remember, your Supreme Court isn't going to come out here and tell us how to live if you don't have, or if I don't have enough gall to go out there and get on the courtroom floor and say, hold her there, troops. We have a problem over here. This city attorney over here is an imposter of an imposter. He's not even a prosecuting attorney. At least the prosecuting attorney can come in here and say his name and his title and his office is provided in the Constitution. What do we got here with this private lawyer working for the city of Boise? And you see how that maxim just fits right in with the other side of the issue? You know, I think I've said before, and I'll illustrate this point. When you're charged in this state with failing to stop at the scale, the issue is, are you loaded? Because if you're loaded with any of these things, you have to stop at the scale. But if your truck is empty, that's the one omission. So when you're pleading the code, what do? There isn't any prima facie evidence that the truck was loaded. Well, of course, unless it's a flatbed loaded with hay, then they can see it's loaded. But if it's a van and they can't see inside of it, you don't let them. Nobody knows, do they? Fifth Amendment comes into play, and good old Hale doctrine comes back into play. Now let's see. In the greatest power, there is the least liberty. Now, haven't we ever heard that one before? That's where too much power begets too much corruption. In obscure cases, we follow that which is least so. In all trials for penal offenses, allowance is made for youth and lack of discretion. Penal offenses, pursuant to contract. That is, what persons are required to obey this penal statute? What penalty is attached to this contract? When you've got a beer license, you better adhere to all the regulations. The ignorance of the judge is the misfortune of the innocent. We've got a lot of ignorant judges, but I'll tell you, judges don't stay ignorant. Judges learn just like you and I do. And we can't say that judges are stupid and that they'll never change. That very same judge that I told you about a few minutes ago has made tremendous strides in the last year. A year ago, she used to yell and scream and jump up and down, rant and rave, and paw the ground and bite the bushes, and threaten you with contempt of court. She doesn't do that anymore, and that's a big change. A general expression is to be construed generally, and a general expression implies nothing certain. Words are extremely important. And every word in law, and you'll find this pursuant to our Constitution and the way it's construed by our Supreme Court, is this. And that is, every word is assumed to have some weight and meaning and to have been carefully thought out. And that's called constitutional construction. And when the Supreme Court is looking at the Constitution and constructing it, they look at every word and the definition and the meaning of the word. What does income mean? What does derived mean? What does derived from mean? And then they'll write a judicial determination. And when you see the Eisner case, when we get into the tax lessons of this course, you're going to find out that the Supreme Court has said there is no tax on tips for you waitresses out there. And there is no tax on labor for you workmen out there. And there is no income tax on commissions, first time, for you salesmen out there. And I could go on and on. Well, suffice it to say now, I think that's enough said about maxims. These maxims are 50 pages, and there must be 50 of them on each page, which means there's literally hundreds of these maxims. You should read the maxims of law, of the common law, and the best source of them, of course, is from Bovier's Law Dictionary of 1914. Go through those at this stage now of your development in this course and get that much information between your ears and the gray matter as we go on to the next lessons, and you have this kind of wisdom and understanding. It's just like reading the book of Proverbs. The maxims of law are like the proverbs of Scripture. They're almost like wisdom, logic, and common sense personified.